Good morning, everybody. Welcome to this Trust Suite training session. We're joined by Alan today. Alan's part of the solicitor team that handle the regulated activity of the drafting a lifetime trust for you. My name's Tom. I'm joined by Phil this morning. Phil's going to be talking to you later on during the session about how the process works. Alan's going to be doing the fun bit and talking about how the trust operates, the tax position behind it, and answering any questions that you've got of a technical nature like that. Once Alan's finished his session, I'm going to hand you over to Phil. Phil's going to run through the process, I suppose, driven side of things, what happens once you've submitted the trust, and address any questions that you've got there. If you're not already following us on LinkedIn, please do follow us on LinkedIn. It's Will Suite, so linkedin.com/Will Suite, and you'll find out any new training sessions that we're going to be running. With that said, I'm going to hand you over to Alan, who's going to run the session for us this morning. Thanks, Alan.
Yeah, no problem. Thanks a lot, Tom. Okay, so the easiest way of explaining the tax side of what's going on with these trusts is to do it on a spreadsheet. What I'll do is I'll work through the spreadsheet, show examples. If there's any questions come up, I will answer them on the spreadsheet. At the end of the session, the spreadsheet will be shared with you, so you can look at the workings, etc. Right, so we have two clients, client A and client B. It's a married couple because that's the simplest example to give. If it's unmarried, it gets a lot more complicated, and that would be something that would easiest to email into support for assistance with. So we're going to start with this married couple. We're going to say they have a house. Each person's share is worth 350,000. We're going to say they have savings of 200,000 each. So each of their estates is 550,000. Now, the thing that we have to always keep in mind is the IHT of this, because this is where the focus of the AAT comes in. So we'll work out their IHT. They have a nil rate band each of 325,000. They have children, so they have a residence nil rate band each 175, 75. So their taxable estate is the total of their estate less the nil rate band less the residence nil rate band, and then IHT at 40%. That times 0.4 plus that times 0.4. So that's their taxation when they die. Simple enough. Hopefully everyone understands that basic concept. Now, the reason our trust is done the way it is because we stick very closely to HMRC's interpretation of what makes the residence nil rate band available. And according to the residence nil rate band interpretation of HMRC, the death of the proprietor has to cause the asset to vest in appropriate beneficiaries, i.e. descendants. There cannot be any discretion involved in that. The death has to cause the property to vest. So the way we wrote our trusts is to make sure that happens, that you don't have to make sure something is done within 2 years to change things. So how that works is we use specific funds. So let's get that AAT, that's short for Asset Allocation Trust. So when they form this trust, we use 3 specific funds: the Residence Nil Rate Band Fund, the Nil Rate Band Fund, and the Excess Fund. Now, the Residence Nil Rate Band Fund is worded within the trust deed as being the smallest percentage of this asset that is needed to be held to claim this, the residence nil rate band. Now, obviously, for this property, the house is worth more than the residence nil rate band, and they need all of that residence nil rate band to reduce their tax as far as possible. So for this example, the residence nil rate band fund for him would need to hold that, and the residence nil rate band for her would need to hold that. Now this fund is held on their trust for the settlor, which means it passes under their will. Now, because this is held on bare trust, it means that the death of the settlor, A, causes this to vest. There's no discretion involved. It passes under their will. So what would be critical here is to make sure that when you draft the will, that this is being treated correctly. So if you did a basic will where he left everything to his wife and she left everything to her husband, when he dies, this amount of the house would then be held for the wife absolutely, which gets rid of any of the trust protection that you're advising on. So you need to make sure that the wills on first death contain a life interest for each other. Now, whether your choice is to have a life interest just in the property, or whether it's to do a life interest in the whole estate for the spouse, that's up to you and your advice. Obviously, he may think, well, we've built these savings up together. I want the savings just to go to my wife, and I want her to have a life interest in the house to prevent it falling to her. Or he may decide she's got enough savings, I'm going to put my savings in life interest as well. What can't happen is his will can't say I give my whole estate to my brother, because then this would not qualify for the residence nil rate band. So the drafting of the will is quite important. Right, then the next part is called the nil rate band fund. Now this can hold up to an amount that does not cause a charge to inheritance tax. So if they haven't used their nil rate band, it could hold a maximum of the nil rate band. If they had made a chargeable lifetime transfer a year ago of 100,000, then the amount that could be transferred into this fund would be the nil rate band less the chargeable lifetime transfer they've already made. So here, what we're putting in is only the house. So the amount that goes into this nil rate band fund is the value of the house less the amount that's being held in the residence nil rate band fund. So £175,000 of the nil rate band is being held here, and the same for her. Now this is a full discretionary trust. So of this full discretionary trust, we need to choose who can benefit. So obviously in his trust, the beneficiaries are going to be his spouse. That way she can continue living in the house, and his children and grandchildren. If there's someone else to benefit, they would need to be in that beneficial class as well. But standard cases, that's going to be spouse plus children. Now, in this case, this excess fund would hold anything over that. So at the moment, this excess fund isn't holding anything, but perhaps he decided that they had this 200,000 is actually in a capital investment bond, and they've got income that supports their life. So they actually want to put all of that savings in as well, in which case, if we add 200,000 to this, it would be more than the nil rate band. So let's say that's capital investment bonds. So if they wanted to put those capital investment bonds in as well, it would take this nil rate band fund to more than the nil rate band. So that would actually be restricted to the nil rate band. And then the excess fund would hold the value of that plus the value of that less the nil rate band less the residence nil rate band less the nil rate band. So this excess fund would end up not adding up. Hold on, why is that? Oh, God, I haven't changed that. So if they transferred in a house worth 700 plus savings worth 400, what we would end up, and this excess fund is again held on bare trust for the settlor, so would pass under their will. So what we would end up with is 175,000 in the residence nil rate band fund to claim the residence nil rate band. This is held on bare trust, so passes under the will, so therefore it does qualify for the residence nil rate band. We would end up with all of the normal nil rate band for each held on a full discretionary trust. And then we would end up with an additional amount because of the savings being 50,000 each held in this excess fund, which are again held on bare trust for the settlor, passes under their will. But all of these assets are in the name of the trustees, so still don't require probate. Even though this is held on bare trust for the settlor, it's still in the name of trustees rather than in the name of the deceased. So it can still be dealt with by the trustees. They don't have discretion on how to distribute this or how to distribute this. It has to be distributed in accordance with the will. And then they have discretion on this part. So you do lose the ability of bloodline planning on anything that's not in this nil rate band fund, because that's the only part where discretion can be applied. But these assets are in the name of the trustees. So that's how the taxes work. So if we decided that we only wanted to put half of this investment in, for instance, then obviously this excess fund would be zero because we'd be taking that out, and the nil rate band fund would then only have 275 in each. So depending on what we flex here, depending on what happens here. So for instance, if we changed it so that they actually had £400,000 in savings, but their house was only worth 250, then this residence nil rate band fund would be restricted, because although there's 175 residence nil rate band available, this would be restricted to the value of the house. The tax would go up as well. And then we have 125,000 held on bare trust because that's all the value of the house. We then have the full nil rate band in the nil rate band fund. And then the balance is held on the excess fund. So that's how these funds flex. So if I move that over to there and then do a basic A, B, and we go back to 350, 100. So that's 450. So that's under. Just to give you a more basic example. So in this case, let's just do a little black line around that so you can see that it's a separate case. So in this one, the nil rate band would be that, and then they're only putting the house in. So the value of the house less how much is in the residence nil rate band fund. Okay, so this is a more basic one. The house is worth 700. They've got 100 each of savings. Their whole estate's not taxable. When this goes into the trust, we still need to fill up. Actually, we don't need all of that in the residence nil rate band because that's taken us over. So the residence nil rate band would be because they don't need 175 of the residence nil rate band. They only need 125 at the time it's set up. So obviously, we rather than restrict the nil rate band fund, we would rather restrict the residence nil rate band fund because that is defined as the smallest proportion needed to claim the maximum amount needed. So we would restrict this to 125, which is then held on bare trust, and then maximize the amount in the nil rate band fund, which is fully discretionary, so has more flexibility. So that's two examples. I see there's no questions being asked, so hopefully that means everyone has understood that. This spreadsheet will be sent to you so that you can have a look at it. So the next thing I want to do is I want to go over the questionnaire itself so that you can understand what the different questions mean. Right, so here I've just set up a test case. Right, so view the questionnaire. So who's a settlor? This is just add a person. It's very straightforward in the standard will suite software. What type of trust is this? It's either a mirror, which means it's a couple, they get one trust each, or it's a single for a single person. We don't do joint trusts. It has to either be a mirror, which is one each, or single for a single person. So then, as this is a mirror, we're adding the spouse, Jane Jones. This question here, you're going to have to tick this no. This question's actually being removed. It's still in there at the moment. It will be coming out in the next release of the questionnaire. So that's the first thing. You're setting up who are the two people, and then if it's a mirror or if it's a single for a single person. Then the next page is trustees. Is the settlor to be a trustee? Obviously, a lot of times they just want to be. Is it a good idea? If they're elderly, not particularly, because if they lose capacity and they are a trustee, it can be a lot of work to remove them. But generally, people want the comfort of knowing that they're still able to have a say. So if you click are the settlors to be included, yes, then that's automatically two people. And sorry, someone just asked a question about discretionary beneficiaries. We'll come to that when we get to the next piece. Are we going to appoint any additional trustees? So in this case, I've said yes, and I've picked Jim Jones, who is their son. It obviously makes sense to have more than just the clients on there if they're elderly. You have to have at least two people, and there is a maximum of 4 across both trusts, not 4 per trust. So if you've got a couple and they've each got 2 children from a previous marriage, and he wants himself, his wife, and his 2 children, and she wants herself, her husband, and her 2 children, that adds up to 6 people, which is more than 4. We can only list 4 people on land registry. So you have to count the total trustees across both trusts have to be 4 or less. Okay, now it's a software generated thing. Could we do it manually? Yes, there's ways, but we have to stick within the realms of what we can do for this product. So that's the trustees. Whether your advice on whether the clients are trustees or not is up to you. Right, next we're going to define the beneficiaries of this discretionary trust part. So include spouse. It's normally going to be yes. There are instances where it could be no. Right, include issue. Now, this is an important question because if they've got children and they want all of their children to be listed as beneficiaries and their grandchildren and everyone else, you just click yes, and that's it. You don't need to do anything else. But if they've got children, let's say they've got 3 children and one of them isn't to benefit, then you would say no here. Because if you say no, then you're going to list the beneficiaries. So you would list the 2 children that they want to benefit, and obviously not the one that they don't want to benefit. But if all of the children are going to be listed as beneficiaries, then just click yes. The other time you're going to use adding other beneficiaries is they might want to add a class of nieces or nephews or a brother or someone if their children can't benefit. So this other discretionary beneficiaries has to make sure you include everybody who could benefit. Include spouses of issue. So they've said, yes, I want all my children to benefit and my children's children. Spouse is something that's very, very client specific. Some people are very much, no, I don't want my daughter-in-law to inherit. And others are very much, yes, if my son's died, I want my daughter-in-law to get it. So this is just a personal choice. If you do pick yes, then you've got the chance to say only if they're married. So perhaps they got divorced just a year before the clients died. So yes. Can the settlor add more discretionary beneficiaries? Now, this is normally going to be yes. The time it would be no would be perhaps where one person had owned the house for 20 years, had decided to gift half of the house to their spouse, but it was a new spouse. They wanted them to have all of this protection and the trust, but they didn't want the spouse to add their sister or something to the beneficiaries after they died. So this would rarely be no, but it's there just in case. Any other beneficiaries? Yes. So we can add a person, we can add a new person and say, Miss Janine, oops, type, Janine Smith, female, relationship, niece. Okay, so now we've added an extra. Include her spouse, no. So that's how we do beneficiary. So the first question we have here is, when do you use the discretionary beneficiary box? Is it for anyone other than children or grandchildren? So this is why when you use it, you either use it when you're not wanting all of the children to benefit, so you want to name quite specific children to benefit, or if you want to have a niece or a nephew as someone as a, if all of the children and all of the grandchildren have died, then I want my niece Janine to inherit. Okay, next. So the other question is, if a partner has a right of occupation in the will, are they then a discretionary beneficiary if children are ultimate beneficiaries? Yes. A right of occupation for a partner, which is, I presume you're meaning an unmarried partner, that has taxable consequences, tax consequences. And if that's in the will, then yes, you would need to make sure you added. So if we go back to discretionary beneficiaries, so let's say this was a woman who owned a house on her own, and she wanted to ensure her partner, according to a letter of wishes, was going to have 5 years to live in the house. She would need to make sure she added the partner here because obviously the house is held in the trust. So you would want to make sure that that partner was included as a beneficiary. Otherwise, they don't have any legal way of occupying the property. So we could edit that person and say Janine is partner. So now Janine would be listed as a discretionary beneficiary. In the letter of wishes, which is something you can prepare, you would say Janine can live in the house for 5 years or whatever you want to do, and cover that off in the will. But anyone who's going to have any right of occupation or inheritance of the house has to be included in the list of discretionary beneficiaries. Right, and so Liz says, if nieces and nephews are listed, does that affect the eligibility for the RNRB? No, because what you're doing here is you're listing the discretionary beneficiaries. The discretionary beneficiaries can only benefit from the NRB fund. The RNRB fund is held on bare trust and passes under the will. Obviously, if you draft a will and you leave everything to nieces and nephews, then the RNRB wouldn't be available. But that's down to making sure that the will is drafted. But obviously, if the property is being left as a life interest for a spouse and then it's passing to the children and all looks well, but the children have died and instead it goes to nieces and nephews, then the residence null rate band's not going to be available anyway because there aren't any descendants to pass it to. I hope that answers your question, Liz. I'm going to say that it's answered. If you feel it needs a bit more expansion, please let me know. Just ticking all these questions off. Okay, so there's no open questions at the moment. Please feel free to type any more if you want. So just remember that the discretionary beneficiaries is only for the discretionary fund. The residence null rate band will pass under the will, so you need to make sure you're keeping that in mind when you're drafting the will. Next, right, final beneficiaries. Now there's two ways of looking at this question. So the way that we draft this is who is to benefit once the clients die, not who would benefit if this trust runs for 125 years, because that just isn't how these trusts are dealt with. What we want to know here is when the clients have both died, what's to happen to the trust? So here's an example of how we generally do it. It's a group. The group is called Children of the Settlor because that's how it comes out in the deed. Distribution is shared. Fallback, yes. Direct issue. So this is going to equally to the 3 children. If any of those 3 children have died, it's going to go to their issue. Simple. That's the clean way of doing this. Now, you can produce the letter of wishes for the client where you can be more specific and say, if your daughter who lives in Australia, your son who lives in France, and your son who lives in Scotland have all died, and all of the grandchildren have all died, and everyone else, I want it to go to my nieces and nephews. As long as they are included in the beneficial class, then you can get as specific as you want in a letter of wishes. Which isn't, you can update letters of wishes whenever you want. They're not reserved documents. You can do them. You can word them as nicely as you want. I have some people I know who do letters of wishes that are 3 or 4 pages long, going through all sorts of different options, and that's absolutely fine. Or a letter of wishes can be as simple as, give my partner a right to live for 5 years, then give it equally to my children. If all of my children have died without issue, then share it equally amongst my nieces and nephews. And that can be done in literally 2 paragraphs. So the letter of wishes can be as complicated as you want. Now, Liz, you typed that same question in the chat box. I've just noticed that. makes it hard to, do you consider, I hope you consider that answered. So I'll mark that as answered. If you don't consider it answered, please type it again in the Q&A thing, right, Grand. And then there's also another question from Liz saying, didn't there used to be an option for joint trusts? There did. We never liked it. We were specifically asked to do it. But after consideration, we decided that it just isn't the way that we designed the trust to be. So we removed the option. It's better from tax point of view to have one trust each. It's clearer on what's happening once one person dies, and there's not a chance that you can lose the residence nil rate band because of it continuing as a life interest for a person. So it was purely just, from a tax point of view, having one trust each makes more sense for making sure we can claim all of the resident nil rate band, etc. Okay, so the last piece of this puzzle is the schedule. Now, normally these trusts are accepting a property. So you add the property here. When you hit add, you're going to be able to choose from an address you've entered before. We want the estimated value because that's how we work out the land registry fees. Who the local authority is, the client's normally going to know that. If you know the title number, put it in. Is it freehold or is it leasehold? If it's freehold, things are generally going to be straightforward. If it's leasehold, they really might not. There are some very simple leaseholds and we can just transfer them. There are some very complicated leaseholds where McCarthy Stone is probably one of the more famous, where it's age restricted leases where they will only put people on who are over a certain age. They want contributions to the sinking funds, and the amount of extra fees can come to thousands of pounds, in which case we will just use a restriction which protects the property but does not make probate easier. Sometimes the leasehold requires certificates from a management company, and yes, we can do that. We charge an extra £100, but it can take months for some of these companies to answer. It's easier for the client to actually get involved, get in touch with the management company, and engage with them so that they know it's happening, because sometimes we will write and write and write and write and never, ever, ever get an answer. So leaseholds can be more problematic and can take a lot longer. Now, we can do properties with mortgages, but if it's got a mortgage or an equity release or anything of that type, all we can do is put a restriction on the property, which means that the probate will not be easier, but you still get the trust protection side of things. So being asked why we need to know who the local authority are. Truth is, we don't need to know. It's just for the land registry forms. It can be blank. It's not a big deal. The land registry form will be generated anyway. So yeah, this isn't critical, but typically people are going to know anyway. So mortgage properties, yes, but if you say they're doing this to make probate easier and it's a mortgage property, it's not going to make probate easier. Buildings insurer and policy number, that's for generating a letter if you want to notify the buildings insurer. Of course, the occupant and beneficial owner isn't changing, but sometimes it's a good idea to let the building insurers know. However, if it is an age-restricted place like Age UK do discount insurance, and one of the trustees is under 50, they may say that they won't do cover and they'll have to change their buildings cover. Overriding interests. This is just a legal requirement for us making a filing. We have to be informed of any overriding interests on the property before we transfer it. Generally, people are going to know, and it's just a case of picking one. if someone's got fishing rights or crown rents or anything on their property, they're going to know about it. It's not a big pain. Again, more questions on the local authority. Yes, we do just use the office that's dealing with it. Traditionally, you put the local authority on, but Land Registry actually find it more useful to put the name of the office that's dealing with it, which we just get from the title document anyway, which is, you know, why I'm saying that, yes, although we ask for the local authority because it's on the Land Registry form, we don't really need it. So it's an optional answer. These aren't optional, but they very rarely get any ticks in it. It doesn't affect anything that we do. It's just it's a legal requirement that we ask. Right, this box here, description of client situation and advice given. It's way underused. It's there so we can understand why the trust is happening, which is really helpful, because if we look at it and you've said that the client wants this because, here we've said the clients wish to exclude their daughter and make probate easier. So make probate easier, but we notice it's got an equity release on it. When we look at the title, we would come back to you and say, this isn't going to make probate easier because there's equity release on it. Exclude their daughter. One of the benefits of putting something into a trust is after 6 years, generally any claims under IPFDA won't be able to succeed against assets that have been in trust for 6 years. It can still go to court. There was a recent case where there was a divorce rather than this, but dependents can still take it to court. There was a recent case where the dependent was successful in being awarded something, but generally trusts are good if you want to either exclude someone or have an uneven split. So you feel that your son isn't doing very well, so you want him to have 80% of the house. Your daughter's got a spectacularly good job and you want to only leave her 20% of the house. It's amazing how many times when you do that in the will, they fight about it. So by doing it in a trust, it means that you can force that uneven distribution. So notes in here help us look at the case and tell you if we think you might have missed a trick or something like that. So this is helpful. And then just draw your signature, save it and finish it. And that's it. So there are no more outstanding questions. So unless there's anything else, I will hand you back over to the team at Will Suite.
Thanks, Alan. Appreciate it.
No problem.
Thank you. So what we'll do, guys, is before I hand you over to Phil, I'm just going to explain a little bit about the process side of things. So anybody who's not yet a user, I can see that a couple of people already using the platform. If you're not already using the platform, we will get you set up. I'll send across a synopsis email this afternoon with a spreadsheet Alan is kindly going to send across, so that you can use that for yourselves. Any burning questions that come in after the session, again, we're always happy to help. What I'll do now is I'm going to hand you over to Phil. Phil's going to run through the process from our side, and then we'll wrap up the session.
Okay, so as Alan just sort of finished up on the questionnaire, I thought it'd be a good place to sort of go from. We've got obviously, as Alan's run through the schedules, the last part of the questionnaire. At this point, all you'll have to do is click on the finish button here, which will take you to what we call the submission page. In the submission page, the sort of distinctive feature of it is that it has a pipeline at the top of your screen. And in that pipeline, you will basically see all the various steps, which is basically the breakdown of the process for Trust Suite. Some steps are more important than others, simply because some of them are simply for your reference, such as the very first step, which is the instruction step. Which is just a way for you to mark that you have taken instruction from a client. As for all other pipelines in Will Suite, you're able to add in notes for each individual step. So, for example, instructions taken, on, and you can obviously set the date above or enter it there if you'd rather. And then all you have to do is click on Save Changes, and that will automatically mark the beginning of your case, if you will. At that point, obviously, we've already, let's say, finished the questionnaire, so you're happy with all the content that you submitted, and what you want to do is upload the ADs. If you try to upload go forward with a case without having uploaded the ADs, the system will throw an error and say, it will basically remind you that in order to at least submit the case, you will need, as a bare minimum, to have submitted the ADs for the settlors and the proof of address as well. Okay, so what you want to do here is click on, in order to submit the ADs, is click on Identification, click View, and then here you have the ability to upload the various ADs. So for example, let's imagine at this moment in time, we only have the IDs for the settlor. We can progress the case just by uploading the settlor's IDs. So we click on Upload ID. We decide what type of photo ID we're looking to upload. For example, a passport. We'll put the passport number, and then once we're happy with that, we just choose the file. Where you will have sort of probably a folder which contains that information. You select the client passport, you upload it, and then it's displayed here. Same principle, of course, with a proof of address. You'll decide what type of proof of address document you have. For example, a utility bill. You'll enter the date, and this one is from the 1st of January 2021. What you want to do then, select the file as well, and just upload a proof of address too. At that point, you'll be asked to tick those 2 boxes to certify that the documents attached are true copies of the original, and that you've actually met this person and can certify they are the documents are correct. So at that point, you click on Submit. The system will automatically upload those documents for you. And then at this point, what you want to do is probably either upload the IDs for the trustees if you already have those. Otherwise, you can just go back onto the submission and add in and submit the case. In order to submit, simply click on the submitted step. Add any notes that you may want the solicitor's team or the solicitors themselves to see. So you just enter here, for example, any notes perhaps you haven't entered in the questionnaire. You might want, for example, questionnaire completed. And then what you have to do is click on Save Changes, and that will allow the system to notify the solicitors that your documents, your questionnaire has been completed and your documents are ready to be approved. Okay, so at that point, what will happen on the sort of end of the solicitor's team, they will look at the documents that the system has automatically drafted, and provided everything has been entered correctly, they will progress the case onto the drafted step. So if we refresh the page now, we'll see that the case is actually, instead of going forward to the drafted step, is actually being regressed to the instruction step. So what we'll be able to do is click on View Log and see, we will actually, as the advisor will actually get notified via email of this, saying your case has been regressed to the instruction step. And then you'll be able to see the comments from the solicitor that says ID is out of date, over 3 months old, please fix and resubmit. So what you'll be able to do is go back onto the identification process, look at the IDs that you uploaded, say, okay, yeah, actually I uploaded an ID which is from the 1st of January, it's too old. So what I want to do is click on re-upload ID, say utility bill is actually from the 1st of I don't know, October, for example, of 2021. So then you click Submit again. Yeah, we might have done something wrong here because I didn't re-upload this. So let's just re-upload the documents quickly, of course. And we have the ability to click Submit again and go back to the submission. Now we're happy that the sort of the proof of address is more more recent. Again, same principle. So we're going to click on the submitted step, state that the IDs have been re-uploaded, and then we'll just put Save Changes. Again, this will notify the solicitors that you've made the amendments they requested. At this point, once the solicitors are happy with everything, they will move the case onto the drafted step. Again, we can see the log, which is very important actually, because it will contain all the notes and communications between yourselves and the solicitor's team and the solicitor. So now if we refresh the page, we can see that the case has now been moved to the drafted step. A common mistake that I think I notice a lot is the fact that people think that when the pipeline is on the drafted step, they think the documents are ready on their system. But actually what that means is simply that the solicitor's team will have looked at the documents produced by the system and uploaded them for the solicitor to approve them. Once the solicitor is happy, reviews the documents himself, so when he gets notified that the documents have been drafted, he will then progress the case to the approved step. He will say, for example, AAT and TR1 uploaded. Then what that will mean is you're going to progress to this step. Obviously, because I'm not a solicitor, but that's what a solicitor will do. We will just progress the case forward to this step. And then obviously, if we refresh now, that's what we'll see. We'll see what the solicitor has done is moved forward the pipeline onto the approved step, which with the note trusted and transfer documents released. And what that will mean in turn is that the documents are now on our system. So now if we go on to the drafted document step, we click view, we can see that a TR1 has been uploaded, a trustee has been uploaded, and a commentary has been uploaded. What that will give us the opportunity to do is download these documents, go to the client and say, here are the documents. You will need to, of course, execute them, fill them out, sign them where they need to be signed. And at that point, once the client, so we then can mark the case as sent to client. Again, this doesn't notify anyone. This is just for your reference. What this will do is it will give you sort of, again, keep you in the loop as to the process and what stage of the process you're at. And once your client has then signed those documents and returned them to you, what they'll be able to do, what you will be able to do is then upload these documents back onto the system. So what you'll want to do is go back onto the drafted documents section and say, okay, trust deed, we've got the signed copy. What we want to do is click on choose file and go on to the downloaded document. Let's imagine the asset allocation trust. And then we've got the TR1 as well. So we can select the TR1 as well. And we just click confirm and confirm. Sorry, I think I didn't click upload there. There we are. Uploaded. We've uploaded both files as requested. We go back into the submission process. We progressed at this point the pipeline forward to the signed step. And just make a note for the solicitors, for example, ID of all trustees is required before submissions. So obviously, because of the first, when we first submitted the case, we didn't actually submit the IDs for the trustees. The system will now notify us and let us know that we will need to submit those IDs in order to progress the case forward to the signed and for the solicitor to then submit the whole case to the land registry. So what we want to do is go back onto the identification tab, and within here, just upload the ID for the trustee. So for example, let's just do this. We click on choose file. We select the relevant document, which is not this one. It should be this one here. It doesn't really matter anyway. And then we choose the utility bill for the trustee as well. So we just put the date as the 1st of October, and we put the various documents. I just picked 2 random documents here just to kind of give you an idea anyway. So you can upload PDFs as well. So, okay, so we then go back to the submission. We should now be able to mark the case as signed, which in turn will notify the solicitors that the documents have all been completed and all the correct IDs has been uploaded. So we mark the case as signed. And what that will in turn do, we'll notify the solicitors that all that it's left to be done on this case in order to be completed is for them to submit it to HMLR. At that point, the land registry obviously will review the process, will review the documentation, and provide everything has been filled out correctly. They will they will create the trust for you. And at that point, we'll have a look. Yeah, we can see that the case has been progressed to the submitted step. We can see that the note from the solicitor is that it's been submitted to the land registry. And then depending on the waiting times that sort of are troubling the land registry at the moment, within a sort of 5 weeks, I'd say is probably a fair representation of the waiting times now. Within probably 5 weeks from the submission to the land registry, the case will then be marked as completed. And that kind of concludes the submission process, how it works. Hopefully, Alan would have given you a good sort of a breakdown of how the questionnaire has been needs to be filled out. Once you've done this, all you have to do is follow the breakdown of all the various steps on the pipeline for the asset allocation trust. And yeah, hopefully it'll be a sort of smooth process. Of course, you have the ability to review the comments, and I always recommend to all of our clients to always click on view log at the top right hand corner of the pipeline, because that will contain all the communication that you've had between yourself and the solicitor, and hopefully will be a useful tool to keep on top of all of the various communications you've had. Okay, fantastic. I hope this was helpful.
Thank you. So thanks, Phil. So just a recap as to what's going to happen next. What we'll do is we will send across a synopsis with the spreadsheet that Alan was using earlier on. Anybody who's not yet already signed up to WillSuite will send across the instructions as to how to get you on board, what you'll need to do. And then we can take it from there. Any questions or anything, feel free to come back to us, but we'll have an email sent across to you this afternoon. As I mentioned before the session, if you're not already following us on WillSuite on LinkedIn, please do so. It's www.linkedin.com/WillSuite, and you'll be the first to know about any upcoming training sessions or any announcements that we've got. And like I say, we'll send across a synopsis shortly. Thank you ever so much for your time this morning. Much appreciated.